Good morning, everyone, and welcome to part 2 of our in-depth estate planning series, providing guidance for minor children and pets. I am Andrea Thermos. I am an estate and trust senior manager with Boulay. I have been with the firm for about 9 years and look forward to sharing some information with you today about guidance for your minor children and pets. Before we begin, I'd like to mention a few housekeeping items. First, you'll notice a link to our interactive Survivors Roadmap Guide in the chat box. If you haven't already downloaded or printed that out, please do so now so that you can reference it or fill it out during today's presentation. During the presentation, I will be focusing on pages 14 and 15 of the guide. Page 14 is the guidance for guardians of minor children, and page 15 is the pet care page. Also note that there's a Q&A box at the bottom of your screen. Please feel free to ask questions using that box throughout the webinar, and I'll do my best to answer them when they're asked. If I don't get to it, I will be sure to answer it at the end of the presentation. Also note, the webinar will be recorded and a link to watch the recording will be sent to you in a follow-up email. So let's get started. No one can imagine the unthinkable, leaving their children behind, leaving them to be raised by someone else. If something were to happen, you would want them left in the very best hands of the person or persons you have selected. Taking the steps to name a legal guardian for your children will ensure the decision is not left up to the courts. It will ensure that you have selected someone to love and care for them as you would. And especially if you have younger children, this step is crucial as they will not be able to express their own preferences about caregivers. Similar feelings can hold true for your beloved pets, your companions, an important member of your family. Including them in your estate plan will give you peace of mind that they will be cared for when you pass away. Today, I'm going to consider the following items: definitions and duties of guardianship, considerations in choosing a guardian, consequences of what happens if you don't have a named guardian, and then considerations for estate planning for your pets. Starting out with definitions. These definitions are general guidelines to assist you in understanding the importance of naming someone in your will to be the guardian of your minor children. A conversation should be held with your attorney through your estate planning process for a full understanding of the appointment of a guardian. Understanding the terminology understanding this terminology will help you focus on making your selection. So we'll start off reviewing some definitions, and then after that, we'll discuss some considerations when making your guardian selection. So, what is a ward? And who are protected persons, and why is there a distinction between those? A ward is your minor child, and the reason that they would be a ward is because they lack sufficient understanding or capacity to make or communicate responsible decisions on their own behalf. They are the person for whom a guardian is appointed. A protected person, on the other hand, is that same minor for whom a conservator may be appointed. Now, while these definitions may seem like the same thing, as we get further into the definitions, you will see the nuances and things will become clear. So the next thing, what is a guardianship? Why would you need that, and how does that help your child? So a guardianship is a legal arrangement in which a guardian is appointed by the court. That guardian has the legal right and duty to care for the ward, and they are selected because the ward has the inability to act legally on their own behalf due to either minority or mental or physical incapacity. So that definition leads us right into the next item of, what is a guardian? The definition of a guardian is that it is the person responsible for decisions about the care provisions and living arrangements for the ward. They will be the person or persons you are naming in your will to care for your minor children. At this stage, this item is probably one of the most important things you will consider when you're drafting your will and making your decisions about that item in your will. You will want to have a conversation with your partner about many of the considerations, and we will be going over those soon in making your selection. A guardian can be appointed in a variety of ways. The most common is through naming them in your will, and then they are, that designation through your will is court approved. In addition to a guardian, you may want to consider a conservator, and you might ask, well, what's the difference? If I have a guardian, my child is cared for. Well, a conservator is the person who's appointed by the court to manage the financial affairs and the property of the ward. So if your child is left in a position that there's assets from your estate that are there for their care, that guardian may be the person who manages both the physical aspects of your child, but also the financial aspects. It is not a requirement that the guardian be both the guardian and the conservator. You can have that responsibility assigned to two different people. And again, it's through careful consideration and discussion with your partner on making those choices and decisions. So you've gone through the process of looking at a guardian, who should be a guardian, possibly having a guardian and a conservator. And they may have been, once they've been appointed by the court, what happens? What are their responsibilities? What things will be expected from them, and how is a guardianship different than being a parent? So a guardianship, again, like I said, can have those two components. It can have the guardian and it can have the conservator, and it can be one and the same person, or it can be two different people. And once they've been appointed, they have distinct duties. They have responsibilities in regards to the child. As I've mentioned, the guardian will typically have decision-making authority, determining where the ward or the child will live. They will have decisions about their medical care and medical needs. And they will also determine what type of education that child may have, whether they're in a private school, whether they're in a public school, whether they go to college, assisting with that decision-making process. A conservator, on the other hand, typically has the power to perform the financial functions surrounding the care and maintenance of the child, paying bills, investing assets, and anything that might provide for their financial needs, including the home that they may be residing in with the guardian. So, with those definitions out of the way, let's look at things to consider when making that selection. You and your partner may have very different ideas about who you want to raise your children. You may have common goals. This list is not all inclusive. It is a list of items to consider and things to think about when you're having that conversation and making that choices. I personally think it's one of the hardest decisions that somebody can make, and it's often something that people put off because they don't want to make that decision. They don't want to face their own mortality. So once we've gone through these considerations, I will tell you about some of the consequences that will happen if you don't name a guardian for your child, and what that looks like versus, you know, completing your estate plan and including your children in your will. So considerations, parenting skills. You know, I think about, I think about my friends and people who maybe would be willing to step in. I know I stepped in as an aunt to babysit my nieces and nephews. And while it was all grand and wonderful, and I loved spending those afternoons with them or spending a weekend with them, I don't know if I would have been in the position to raise them 24/7. So when you are thinking about the person or persons that you want to name, really consider that. Is the person you're thinking of somebody who has a willingness to step into that 24/7 permanent kind of outlook of I'm going to be caring for them until they are of majority age. Considerations with the parenting. Is it somebody who already has kids? Will that help them embrace your kids and bring them into the fold of their home? Maybe you want someone who doesn't have kids, who has the ability to really focus on your child or your children and give them the love and support and the guidance that they would need with one-on-one attention and not other children into the mix. You know, those are all very important considerations. Next thing, not thinking long-term. Often, as a parent, we think, well, gosh, our own parents did a great job. We should possibly consider them as the guardian. Well, from a long-term perspective, consider, you know, the age of the people you're considering, not only your parents, but maybe you have an aunt or an uncle that you're considering, or a close friend, other relatives. Really consider what's the long-term outlook. You know, could something happen with their marriage? Could one of them pass away and they're no longer in a position to take on this role or responsibility? Do you have concerns that a couple might not have a stable marriage? You know, if one of the guardians that you've named passes away before you update your will, and the other one isn't able to take on the role by themselves, that may cause some problems. So creating a backup plan and answering the what ifs could be a smart move, and leads me on to the next item of naming only one guardian. So when your will is drafted or your legal document is drafted, you have the ability within that to say, this is my first choice, and this is my second choice, and possibly this is my third choice. And what that does is allows you to name multiple individuals or multiple couples, so that if something long-term happens, it gives you the ability to know that in your plan you've named multiple people, and if that first person can't take on this role and responsibility, the court will move on to the second person and the third person. It will offer you some insurance and assurances of that being a good thing. The other thing to consider on the naming only one guardian is, consider their age. Where do they live? A young candidate, somebody who is in their 20s, is just starting out their career, maybe starting a family of their own. While an older candidate might not be ready to be a parent again. They might have the attitude, I've been there, I've done that, I don't want to do it again. I'm happy to be the grandparent or the great aunt or whatever, but I don't want to be that, I don't want to have that responsibility. All of those things are really important considerations when going through this process. Next, location and living situation. Are you Are you a city dweller and you want your kids to be raised in the city, and you have family members that are maybe outstate or rural, and that's not how you want your children raised or where you want your child raised? So location of where your possible choices are living is a huge, could be a huge consideration. And there's no guarantees. You know, you maybe picked somebody when you first drafted your documents, and that person has switched careers or switched goals in their life, and they have once lived in the city and moved country, or vice versa. Always keeping those things into consideration. In most instances, if you have a named guardian, that guardian will take your child or children into their home. On a rare occurrence, the guardian moves into the home where the children have been living with their parents. But more often than not, it's the case where the children are moving in with the guardian. So is it important to you that they have the ability to live where you would like them to live, or to keep your children kind of together in one home, in a environment that they've been comfortable with? Those are all, you know, again, good things to consider, and items to think about and discuss with your partner. Next, religious and moral beliefs. You know, we all have our beliefs. We have a system that typically came from our childhood. We, you know, we have our base based on our own history. So I think that this is a huge one. Do you want your children to be raised in a situation that's similar to your own, one in which you're going to have the same religious education, the same religious upbringing, the same religious exposure? You know, is the person you're considering somebody who would embrace that? Are the people you're considering on the same page as you from a morals perspective? You know, you're never going to find somebody who aligns with you 100%, but you really, if this is a huge important thing to you, this is something that you need to have high on your list of the people you're choosing, and how you want your children to perceive those items. Something of note under the religious and moral belief item is people often believe that if your child has a godparent, that they can become the legal guardian of their child, that they don't have to do a will, or they don't have to do that legal process of writing down who they want to be the guardians of their children. Godparents are not considered legal guardians unless it is stated in a legal document that those same people are who you want recognized as potential guardians for your children. Next on the list, job and financial stability. So as I was going through the definitions, we talked about guardian and conservator. And in some situations, your estate may not have the means to support your child through their life. So when you're selecting a guardian, you may want to take that into consideration. Will that person be able to take your child into their home, and are they okay also being financially responsible for that child? In other cases, the parents have, you know, enough wealth that a trust or something can be set up for their child. And that's where that conservator comes in, where they're managing the trust, or they're managing the financial assets of the parent's estate and there are means to support the child, and the guardian maybe doesn't have as much financial responsibility. So the finances and your own finances and where you are financially can play a huge role in your decision of again, who you want to have on your list of people to choose. So those first items, those items that I just talked about, are all things to consider when you're thinking of who you want to be your guardian. So once you've made that decision, the last item on this list of considerations is providing detailed instructions. So, you know, I started off with imagine the unthinkable, that you aren't there to raise your children. Well, in the unthinkable, if you have school-age children, for instance, who are their friends? What are their activities? Where do they go to school? What's important to them? You know, what TV shows or what computer games or what things are important to their life? The person who takes on the role of a guardian would be so appreciative to have something that tells them some of those things. Maybe you have a very small child who can't express their own needs or desires, and knowing their routine, you know, do they have a bedtime? Do they like certain foods? Do they have people that they have play dates with? Those kinds of things are really hugely important. And maybe you have, you know, as a parent, you have an ongoing maybe summary or document that you're updating that on a semi-annual basis, where you're listing out, you know, your children's school teachers and their pediatrician and who their friends are and what activities they're involved in, and how do you find all that information? Because I know myself, if I had to step in as a role of a guardian, it would be a blessing to have that kind of detailed list that lays out, you know, what my hopes and dreams are for my child, but also just what their daily life looks like. So it's a twofold thing. It gives me peace of mind as a parent to offer that information to the person who may be taking on the role of raising my children. It also gives the children some normalcy and some stability in those early days when they have lost their parent. So, you know, as a parent, I would hope that your wishes would be honored. And you can't guarantee, again, you can't guarantee anything about what happens if you were to pass away, but making your wishes known of how and where they're raised and maybe where they go to school could be just a huge thing for the people who step in as their guardian. So consequences. Sometimes people think that taking no action and leaving things in the hands of the law will get the same results. So some considerations. You know, nobody enjoys the nature of this topic, but what will happen to your children if you do not name a guardian? It's an uncomfortable reality, and understanding it early on maybe will be the thing that pushes you to, you know, name that guardian and have that conversation with your spouse or your partner and just make that decision. So what happens if you don't have a named guardian? They become basically they become a ward of the state. And what that means is the court system and the judge in the family court gets to make the decision that they think is most appropriate. And there can be problems there. So let's say that you have in-laws or grandparents that don't agree. So you could have fighting about that. Maybe the person that the court system deems to be the most appropriate guardian is not the person you would have selected. You know, maybe you have had a conversation and you did determine that you didn't necessarily want the grandparents to be raising your children. A judge may make a different decision. And if you haven't let your wishes be known, it becomes an option of the court. Back to the financial piece of things. So if you have a child who's a ward of the state, there will be a conservator that is appointed to manage the assets for that ward. And upon the child reaching age of majority, they will have complete access to those assets. So if you're a person who has a significant amount of wealth and your child gets access to those items when they turn 18, will they have the base and the financial understanding to really manage those assets appropriately? So leaving their care and their financial choices up to the court can leave them in a really bad position. Another consideration for blood relatives is, you know, a blood relative may be the most logical choice to a judge, but maybe you had a very close friend or a family, a distant family member that you had in mind. And if you didn't make those choices known, the court won't know that. And again, the judge is always going to be trying to work in the best interest of your kids. They're just going to do what they think is right. And most often they're going to follow family lines. The last point on here is the foster system. So if you have not left instructions and you have not done any documents that name a guardian for your child, while they're in the court system and while this is trying to be settled, they could end up in the foster system. And not that that's a bad thing, but is that the best place for them to be when they've lost their parents or parent? So all very significant things to consider in choosing a guardian. So just before I move on to pets, that guardian decision shouldn't be taken lightly. It should be contemplated and discussed, and you really should have good conversations with each other as parents. I believe it's your responsibility. You always want what's best for your children, and this is in their best interest. You naming somebody or several people who you would want to take on their responsibility and their care if something were to happen to you. So, moving ahead, estate planning considerations for your pet. So Minnesota, surprisingly, was the last state to enact and establish a trust law. I found that surprising, and Minnesota enacted that law in 2016. When I originally did research for this guide, I was surprised to learn that I don't remember which state was the first state to enact it, but it was in the late 60s. So I don't know why it took Minnesota almost 50 years to enact a statute that would allow us to care for our pets. So you might wonder, well, I can just put something in my will. So legal definition of a pet. So for estate planning purposes, the law requires that when you die, your personal property must be passed to your rightful heirs or beneficiaries. The issue with pets is that while they while legally they are personal property, if you die, you really don't want them treated as the furniture they sit on. Because they are property and not people, they cannot inherit from you as you can inherit from your estate, as an heir can inherit from your estate. So before we had any laws in place, you could build things into your will or into your trust document, talking about the care of your pet, but the trustee or personal representative was under no legal obligation to satisfy those wishes. So as I said, in 2016, the Minnesota legislature adopted the Trust for Care of an Animal statute. The law enables a pet owner to create a trust to provide for the pet's care after the owner's death or during a period of disability. The enacted law now allows you to establish a trust to ensure your pets are cared for after you have passed. So it doesn't mean that you have to leave your whole estate to your pet or your pets, but you can have money set aside that will offer proper care for them after you die. And the trust can be set up for one pet or multiple pets. So it's not that you have to set up a separate trust for each pet. You can have one pet or one trust that will oversee the care of all those pets. So how does that trust work? So it's a trust that can be in place until the animal dies or for 90 years, whichever is shorter. Well, for those of us that are dog owners or cat owners, it's very unlikely, I'm absolutely positive, that they would not live for 90 years. There are some turtle species or tortoise species, however, that do have longevity and could outlast that 90-year term, but very highly unlikely that many people have that. So, so this trust can be in place for the lifetime of the animals. So if you have a young puppy, when you pass away and you have an older dog, the animal that lives the longest is the one that will be provided for, as long as it doesn't exceed that 90 years. The animal trusts provide a much needed mechanism, legally requiring any money in the trust to be spent on the animals for which it was created. And the trust may take effect if the owner dies or is still alive but incapacitated. And they can be set up, as I said, for either a single animal or a group of animals. The money in the trust remains earmarked for the animal's care and only the animal's care. It can't be taken out for any other reason until the last one named in the trust dies. So that's important. It says until the last one named in the trust dies. So if you have pets, and let's say that you have 2 dogs and 3 cats, when you write this document and one of them passes away prior to the trust being put into effect and you get a new dog, if you don't add that dog to that document, then they aren't provided for in there. So it's important to remember that you have to not only create it, but review it when you have life changes with your pets. So once that last pet passes away, any remaining funds in the trust will be distributed among other heirs or as directed by the trust terms or by the court. So if you have a pet trust, and in that trust, you may say, upon the last to die of my pets, I want the remaining money to go to the Humane Society, for instance. You can set your trust up so that the assets from that trust will go as directed. If it's silent, then it goes to your heirs per stirpes. So that's the mechanics of, the basic mechanics of a trust. Again, I would encourage you to seek out the assistance of an estate planning attorney, possibly somebody who has had experience with pet trusts. The last item on my list here for estate planning for your pet is, again, detailed instructions. Just like with your children, your pets are members of your family. They're important. They're important enough for you to have included them in your estate plan. Because they can't talk, they can't tell you anything. They can't tell that new owner or care provider anything about what their needs are. So make sure that you have something in writing that details what their care looks like, what their routine is. Maybe a dog park that you enjoyed taking them to, or they enjoyed romping around in, who provides their veterinary care, and what kind of maybe life that you would like to see them have. The trust, along with a detailed instruction, can give you peace of mind that this is an important member of your family and they will be cared for upon your death or incapacitation. I thank you all for joining me today to discuss these important items in your estate plan. Our last webinar in this series will be held on Thursday, February 11th at 11 a.m. In that webinar, I will be discussing how to organize your digital and online accounts. Additionally, we have a new guide that will be part of that presentation and will be released at that point. I also want to mention the services that Boulay provides regarding estate planning. We can help you review your current estate plan and estate planning documents and offer recommended updates. We can also assist you in setting up an estate plan. Thanks for your time today, and I hope you all have a wonderful day.